This is a very short summary of key ideas and rules of stare decisis as they apply to legal research and writing. So, stare decisis is a starting point for judicial decision making and essentially means let the decision stand. Stare decisis refers to the idea that courts will follow their own previous decisions and those of higher courts within their chain of appeal when they approach decision-making in a new case. Stare decisis serves a number of purposes. Consistency and fair treatment. In other words, the idea that people in similar situations should be treated the same under the law. Second, stability and efficiency in judicial decision-making. So each judge does not start from scratch in approaching a new case, but as one famous quote goes, can lay his bricks on the foundation of the law that's already been built. And then finally, predictability for future litigants. By checking previous decisions on the same issue, a lawyer or a litigant can predict what the likely outcome in a future case with the same issue and similar facts will be. As the Supreme Court has put it, stare decisis, we have stated, is the preferred course because it promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. In fact, more than once the Supreme Court has called stare decisis the foundation stone of the rule of law, necessary to ensure that legal rules develop in a principled and intelligible fashion. So let's take a look at how stare decisis works in practice. Let's see. First of all, it's going to be the starting point for legal research. If your goal in legal research is to find controlling law for your client's situation, then of course you need to know what controlling law consists of. Second, it's also the starting point for the same reason for legal analysis. You need to know which decisions your judge will look at first when deciding what the controlling rule is that will affect your client's case. And then similarly, it's also the starting point for legal writing because to meet the expectations of a legal reader, you need to begin with the most authoritative sources and the controlling legal rules. So let's look at how stare decisis works in practice. This is the Wisconsin state court system. The trial court level is called the circuit court level. Then Wisconsin has a so-called unified court of appeals, so even though there are 4 geographic districts, they're considered to be one court of appeals. And then the high court level, as in many states, is called the Supreme Court, the Wisconsin Supreme Court. So it's relatively clear that if a case is pending in the trial court level, the circuit court level, a lawyer preparing the case or predicting what the judge at the circuit court level will do will look first to the high court in the jurisdiction on questions of state law, the Wisconsin Supreme Court, and next the Wisconsin Court of Appeals is also going to be binding. And as in most states, the trial level decisions are not actually published, so we don't really need to take that into account for purposes of stare decisis. But according to the general rule, you look to higher courts in your chain of appeals. So for the Wisconsin state court system, that would be the Wisconsin Supreme Court and the Wisconsin Court of Appeals. Okay, similarly, if we look at the federal court system, there are also 3 levels, but it's slightly different, as you can see, at the Court of Appeals level. In Wisconsin, we would be either in the Western or Eastern District of Wisconsin. Here in Madison, it would be the Western District of Wisconsin. And So the courts in the chain of appeal on a federal question would be the United States Supreme Court first, then the Seventh Circuit, which has jurisdiction over both the Eastern and Western District of Wisconsin, and then if the Western District of Wisconsin had written and issued any published decisions, a litigant in a case pending in the Western District would also look for those previous decisions. So once again, even though the federal court system is more complex than the Wisconsin example, it still follows that general rule of the higher courts, looking to the higher courts in the chain of appeal. What is a little different in the federal system is that at the intermediate appellate court level, it is not a unified system. So the first, second, third, fourth, etc. circuit courts of appeals are considered to be sister courts to the Seventh Circuit. And one decision of another circuit does not bind the Seventh Circuit as a sister court, and it also therefore does not bind the lower courts within the Seventh Circuit. So it's a little bit more straightforward, or not, depending on how you look at it, in terms of following this chain of appeal. So even though, say, the Third Circuit is a higher court than the Western District of Wisconsin federal court, that court would not be bound by the Third Circuit's decisions because the Third Circuit is not in the Western District of Wisconsin's chain of appeal, and there is no unified intermediate appellate court level in the federal courts. All right, now let's look at the so-called hybrid situation, which is a little bit more complicated, but which a lawyer may run into now and then. And that is, what if you're in one court system, but the judge is applying the law of the opposite system? So for example, in the federal court system, in a diversity jurisdiction case, for example, you might be in the United States District Court for the Western District of Wisconsin, but even though that's a federal court, if it's a diversity case, the judge will be applying state law, so Wisconsin state law in this example. So that raises the question about how stare decisis changes, if at all, if you are in this unusual situation. And so not surprisingly, on questions of state law, even though you're in a federal court, the first court to which that federal judge will look is the Wisconsin Supreme Court. So that's going to be the most binding authoritative source on questions of state law. Now, even though it's a state law question, your court, your federal district court, is still going to be bound by the same courts in its ordinary chain of appeal. So in addition to the Wisconsin Supreme Court cases on state law, if any of the federal courts in the Western District's chain of appeal have considered this particular area of state law, the U.S. District Court will, of course, still be bound by those higher courts in its chain of appeal. Now, the slightly counterintuitive question, perhaps, that comes up has to do with the Wisconsin Court of Appeals. If the federal courts are going to be looking to the state courts for interpreting questions of state law, the question would arise whether federal courts are going to be bound by the intermediate state court interpreting questions of state law. I suppose the reasoning might be that, well, state courts, even intermediate state courts, have more experience in interpreting state law, so shouldn't they be authoritative on state law questions in a federal court? And the answer is no, actually. Well, they might be persuasive, highly persuasive, but they are not binding on federal courts, even on questions of state law. And there's plenty of judicial precedent and a lot of language in both the state courts and the federal courts confirming that. So even though the federal courts may well look to the Court of Appeals if the Wisconsin Supreme Court has not spoken on that particular question of state law, the Wisconsin Court of Appeals is not binding on the federal courts. Okay, last question perhaps that you might have on this idea of stare decisis in the federal court system applying state law is the situation, which happens once in a while, in which perhaps a federal court, without guidance from the state courts, has made its best guess on how the Wisconsin Supreme Court would interpret a question of state law, and that of course becomes binding on lower federal courts. And let's say then subsequent to that decision, the Wisconsin Supreme Court does in fact interpret or consider the same question and contradicts what those binding federal courts have said about state law. Does then the lower federal court have to follow its own higher courts, which of course are binding on it, or must the federal court follow the later Wisconsin Supreme Court decision on this question of state law? And the answer is, even though a higher federal court may have issued a contradictory opinion, once again, the U.S. Supreme Court has declared all of the federal courts would then be bound to follow the Wisconsin Supreme Court's interpretation of state law. All right, now, final situation, I guess actually the flip side of this one. Let's get rid of this highlighting. What if you are instead in a state court and the judge is considering a question of federal law? Occasionally, part of a state court or state law case may also involve a federal question, and so state law judges or state court judges may be applying federal law. Well, just as in the opposite situation, it's no stretch, of course, to note that the Wisconsin Circuit Court, the trial courts in Wisconsin, state courts, would look first to the United States Supreme Court in interpreting federal law. The United States Supreme Court is the final arbiter of federal law. And then similarly, once again, to what we just talked about, the Wisconsin Circuit Court would still be bound by the courts in its own chain of appeal. Therefore, it would have to follow the Wisconsin Supreme Court if it had interpreted that federal question, as well as the Wisconsin Court of Appeals. So essentially, this situation, a state judge or a state court considering a federal question, would work in the same way as a federal judge considering a state law question. It gets kind of confusing here. But what you need to remember is that in this unusual hybrid situation where a court is considering a question of law that is not, I guess, in its own bailiwick, it would look first to the high court of the other system for binding cases and then follow its ordinary chain of appeals. So this is the Wisconsin example interpreting federal law, and we just talked about the federal court example interpreting state law. So that is all I wanted to cover, and I hope this has been helpful. Let me know if you have questions.